The following message has been authorized by Alberta Accountability Alliance. abpolica@gmail.com.
And red tape reduction.
Thank you, Mr. Speaker. I rise to introduce Bill 34, the Access to Information Act. The proposed act is one of two pieces of legislation created to replace the Freedom of Information and Protection of Privacy Act, or FOIP. The modernization of the FOIP Act will allow Alberta to fall in line with policy from every other province in the country, as well as the federal government. The need for cabinet confidentiality is recognized unilaterally by governments across the country, as well as the Supreme Court, as essential to good governance. I therefore move first reading of the Access to Information Act.
The Honourable Minister of Service Alberta and Red Tape Reduction has moved. First reading of Bill 34, Access to Information Act. All those in favour of the motion, please say aye. Aye. Any opposed, please say no. In my opinion, the ayes have it. That motion is carried and so ordered.
Bill 34, Access to Information Act, is now read a first time.
Good day. It is Darrin Thompson. We are the Accountability Alliance, the Alberta Accountability Alliance, and we are here to call out to all Albertans that it is urgent that you go to the change.org/call to reserve royal assent petition and sign this petition to ensure that we urge Lieutenant Governor Somalikanni to reserve royal assent on Bill 34. As you can see, during the first reading of Bill 34, it was a 1-minute session, 1-minute part of the session, and all nays, no no's. No one responded negatively towards that, and that scares the heck out of us. Always like, subscribe, do all those sort of things. We've got a lot to get through, but we're going to try and be quick. We're going to try and be as concise as possible and let you understand why this reserving of royal assent is as important as it is today. So first off, we go to the Say No to Bill 34, Access to Information Act, which is what we're asking for, reserve royal assent. Go to aballiance.ca. You can see the whole thing, but also go to the comments below the link to the petition and make sure you sign that. We've closing in at 100 right now on Friday afternoon. We want to get this thing, ultimately, we want this thing to be in the hundreds of thousands, if not millions. Everyone in Alberta needs to understand Bill 34 is bad. It is not just access to information. It's not just we're going to change things for FOIP. It is much, much worse than that. So again, you can look on the website, scan the QR code, go to the link that we're showing. So if you look at the order paper, the second reading of this bill is Monday, November 18th. So we're days away from the second reading of the bill. And if you zoom in on the calendar, the link is in the comments there, you'll see that December 5th, which is a Thursday, December 5th, is the last day of session in 2024 for this UCP government. So we know that if they can get the second reading passed, they're going to push to get this thing through by the 5th of December, and then royal assent can come out and Lieutenant Governor Somalikanni can rubber stamp it like they have done on all other bills, and we want to prevent that. So that's why we're here today, to discuss this and try and keep this within a 10-minute window so you guys can we're not taking your time, but you're understanding this sort of thing. So the big thing is Division 2, the exceptions to disclosure. And these are exceptions of what the FOIP request is going to be accepted from. So disclosure harmful to a business interest or third party, disclosure harmful to personal privacy, disclosure harmful to individual or public safety, confidential evaluations, disclosure harmful to law enforcement, workplace investigations, disclosure and complaints, disclosure and harmful to intergovernmental relations, cabinet treasury board confidence, local public body confidences, advice from officials, disclosure harmful to economic and other interests of the public body. So records to which this act applies, this applies to all records in the custody or under the control of a public body, but does not apply to the following: information to a court file, court database, or any other record system used by a court, record of a judge or court of appeal, the Court of King's Bench or the Court of Justice, record of an application judge of the Court of King's Bench, record of a justice of the peace other than the presiding justice of the peace under the Justice of the Peace Act, a judicial administration record or record relating to support services provided to the judges on any of the courts referred to in this clause. So basically what you're looking at is a lack of information on judges, a lack of information on the court system, a lack of information available on cases and things that are regularly needed and have been accessed by the public. And it really is going to affect your media. So any of you that are watching your local media, your Globals, your CTVs, your CBCs, or reading the local paper, or even the independent media, the access to these documents is going to be limited, if not at all. A personal note, communication, or draft decision created by or on behalf of a person acting in a judicial or quasi-judicial capacity, including any authority designated by the Lieutenant Governor in Council. A quality assurance record as defined in Section 9 of the Alberta Evidence Act. Record created on behalf or is in the custody of under the control of an officer of the legislature relates to the exercise of that officer's function under the Act of Alberta. Information that is collected by or on behalf of in custody under the control of the Ethics Commissioner relates to the disclosure statements of deputy ministers, other senior officers, and things that have been filed within the Ethics Commission. Record that's created by or on behalf of in the custody under the control of the Ethics Commissioner relates to any advice relating to conflicts of interest, whether or not the advice was given under the Conflicts of Interest Act. So when Premier Danielle Smith was contacted by certain people in regards to court cases, that would be under a conflict of interest. While we wouldn't have any of those sort of conversations disclosed because Bill 34 will protect it. A question to be used on any examination or test teaching materials of an employee of a post-secondary educational body, or both an employee or post-secondary educational body and the post-secondary educational body. Research information of an employee of a post-secondary educational body. So basically what you're looking at is you will not have access, public will not have access to these information in regards to an employee of the post-secondary so your universities and your colleges, or the teaching materials of such person, which then opens up that Pandora's box of if someone is a convicted abuser or has cases pending on potential abuse or sort of thing, you wouldn't know that because these documents are protected. So what we're looking at is basically your documents that you'll have access for are documents on your own. You won't be able to ask for documents regarding anyone else. Record relating to the prosecution or potential prosecution, including any charging recommendation if all proceedings in respect of the prosecution have not been completed. A record including any charging recommendation created by or on behalf of that is in the custody or under the control of a prosecutor relating to a prosecution or potential prosecution. So basically you will not have access to your if you are involved in a case and you are the defendant, you will not have access to any sort of charging recommendations if they are provided and they don't want to give it to you. So you're basically flying blind in regards to and very much at a disadvantage in regards to defending your rights and freedoms in a courtroom. Record in the custody or under the control or record made from information in the personal property registry, the offices of the registrar of motor vehicles, the office of the registrar of corporations, the office of the registrar of companies, a land titles office, and the office of the register of vital statistics. Again, anything that is in the custody of where you're registered, so businesses, corporations, vehicles, land titles, those sort of things. If that information is needed for a case or for a conflict of interest or anything sort of that, you will not have access to those because they're protected under Bill 34. A personal record or constituency record of an elected member of a local public body, a personal record of an appointed or elected member of the governing body, a personal record of constituency record of a member of the executive council. Again, look at the UCP, look at the TBA, look at all these sort of colluding partners in our current government. You will not have access to any conversations, any communications between these parties. A record created on behalf of the office of the Speaker of the Legislative Assembly or the office of the member of the Legislative Assembly that is in the custody or under control of the Legislative Assembly office. So Speaker of the House, Speaker of the Legislature cannot, if any records that are done by Mr. Cooper will not be available to the public. A member of the Executive Council, member of Legislative Assembly, or chair of a provincial agency is defined in the Financial Administration Act who is a member of the Legislative Assembly. So basically anyone in cabinet will be protected by Bill 34. Also been sent to or be sent to a member of the Executive Council, member of the Legislative Assembly, or chair of a provincial agency. And it goes into the document. It's an 80-plus page document. We have the link in the description. You can go and look at it yourself. We'll go into further depth. We're just going the first 20 pages today, and we'll go into further depth down the line. A record of communication between a political staff or member of the Executive Council and political staff. So what we have from our friends at the Breakdown with the Skybox scandal, none of the information will be public record. All communication between political staff and member of the Executive Council and political staff will now be protected under Bill 34. A record in the custody or under the control of ATB Financial, other than a record that relates to a non-arm's length transaction between the government of Alberta and another party. Record relating to the business or affairs of a credit union, Central Alberta Limited, credit union or dissolved credit union relating to an application for incorporation as a credit union obtained or produced in the course of administering or enforcing the Credit Union Act. Record of information referred to in Section 123, Credit Union Act, or respecting loans made by a credit union are assumed to by the Credit Union Deposit Guarantee Corporation. So if you have governing body or political third-party advertiser, you really can't do ATB or credit union. But if you do, those documents will now be protected under Bill 34. Health information is defined in the Health Information Act that's in custody or under control of a public body that is in the custodian as defined in the Health Information Act. A record relating to an audit by the Chief Internal Auditor of Alberta in the custody of the Chief Internal Auditor of Alberta or any person under the administration of the Chief Internal Auditor, irrespective of whether the record was created by or for supplied to the Chief Internal Auditor. A record in the custody or under control of the Government of Canada or its agencies, the Government of a province or territory of Canada or its agencies, other than the Government of Alberta or its agencies. So any sort of communication between our provincial government and the government of Canada or its agencies or any sort of agency territorial cannot be disclosed or will not be disclosed, protected under Bill 34. Relation to University Board of Governors or the General Faculties Council described in the Post-Secondary Learning Act. So all these acts are being done under the guise of we have a majority and we don't really need to debate or anything like that. Currently, the Lieutenant Governor Lacani are rubber stamping these acts. So go and look up the Post-Secondary Learning Act, and you can see that your university and board of governors and their faculties council are protected under this Bill 34. So any discussion between the government and these parties and interprovincial or anything like that, they're all protected under Bill 34. In relation to the comprehensive community college or polytechnic institution, the Board of Governors or the Academic Council is described in the Post-Secondary Learning Act. Again, Post-Secondary Learning Act protecting post-secondary institutions from having to disclose things publicly. Political staff, meaning political staff is defined in the regulations. For the purpose of the subsections, blah, 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 non-arm's length transaction is a transaction that has been approved by the Executive Council or any of its committees, Treasury Board or any of its committees, or a member of the Executive Council. So basically, any staffer that is determined by the Executive Council, current UCP government, the Treasury Board, which could end up being Stephen Harper, former Prime Minister of Canada and current IDU Vice Chair or Chair of the IDU, my apologies, or a member of the Executive Council, which again is your UCP government. So anyone they deem as a staffer is protected under Bill 34. Power to disregard requests, and this is where we're going to end off here. So right now, if there is a FOIP request put in, it basically has to, as long as you're following the guidelines that are very limited, you can request basically anything on for FOIP, as proven by our allies from the breakdown that got FOIP requests from the government that had the Skybox scandal, which under Bill 34, that Skybox scandal information would never be disclosed to the public. So the head of the public body may disregard a request made under Section 7 if responding to the request would unreasonably interfere with the operations of the public body or amount to an abuse of the right to make a request because the request has been made repeatedly or in a systematic nature. So if we look at our independent journalists that continue to send in FOIP requests for the same thing that the government or the premier of the province refuses to answer, if you send more than one request, it will probably be denied because they claim it under the power to disregard. The request is abusive, threatening, frivolous, or vexatious. It is made in an abusive or threatening manner. So you can't tell F the UCP or anything in your request, which most logical people wouldn't do that, but they determine what is frivolous. So it's under the determination of the person and the board selected by the lieutenant governor on the suggestion of Premier Daniel Smith and their cabinet. So we're going to tell you who we want you to sign off on, and they're going to protect us from the public getting to know any of the information that should be public knowledge. Information request relates to something that's already been provided to the applicant or is made available to the public. So they'll claim this thing if they give some sort of weak answer, then that information has been given to the public. So if we answer, yeah, we've already said this, or the typical Danielle Smith lines of we're not going to go there, or you've already any of these sort of things. If you determine that you are asking the same question that's already been asked, or just asking for the same information that has not in your eyes been given to you, but in their eyes it has, you will be denied. Despite receiving further information from an applicant under the section, the request does not meet the requirements. So they determine what the requirements are for you to get the FOIP request, and then they determine the amount of money they're going to charge you for said FOIP request. Yada, yada, yada. Protected under Bill 34. So again, that is a quick sort of quick information. We're trying our best to get things out here. Like we said, we're asking, this is the call out to all the influencers, all the people with mass audiences on multiple platforms. We're talking about the Jespersons, we're talking about Lisa, we're talking about Boots, we're talking about Brittlestar, we're talking about librarians. Any of you that have these great audiences and you've got them captured, we need you to promote. First of all, you need to sign the application, the petition, and then we need you to promote that petition, because we need all the signatures that we can to make this actually have an effort to stop this bill from being rubber stamped with the royal assent. That's all we got left, is the royal assent. There's no election coming. There's nothing that we can stop it in regards to. I mean, even if we file lawsuits, the government has multiple law offices under retainer, and they will tie everyone up in frivolous lawsuits until they bankrupt you. Look at certain people that are being sued by the Edmonton police and the chief of police, and look at what they're going through. We don't want that. We don't want any of this. And this is, like we said, this is what you have to understand. This isn't political. It's personal. I don't care what side of the aisle you're on. We're not talking about if you're a UCP supporter or an NDP supporter. It doesn't matter. Because if this thing goes through, then this is a tool and weapon that can be used by any government in power. So in 2027, if the UCP get voted out and a certain party gets in that you don't like, they hold that power now. So we don't want the UCP to have that. We don't want anyone to have this power. This is ridiculous amount of power. This is true attacks on our rights and freedoms. And just because you are not facing any of this stuff right now doesn't mean it's not coming. Just because if you believe in the UCP and you believe in Danielle Smith and she's doing a great job and you are part of the Black Hat gang and you all this sort of things, and she's doing the things that you want her to do, that's great. But if they flip the script and you give them this power, you have none. This eliminates any sort of recourse on this government until there's a chance at the election, and we know they're going to delay the election as far as humanly possible. Again, go to our website, aballiance.ca. Click on the petition, sign the petition, share the petition. Everyone, we need everyone in Alberta to get behind this, because the only way we are going to stop Bill 34 is if we all come through united. Want one of these cool toques? Visit our website, abpoly.ca. We've got the toques. We've got signs in regards of the reserving royal assent. We got new t-shirts. My Alberta cares about social equity. They're all there. The social equity shirts, coffee mugs, and signs are going for all net proceeds are going to the, where we go, the co-fi.com account. which is we're building because we want to do billboards. We want to do a big advertising marketing campaign, but we need your help. We need your support. And like I said, you get some cool merchandise. If you get the breakdown toque, all proceeds go to their FOIP fund, and they're going to need a lot of funding for their FOIPs. If you like what Nate and the crew do at the breakdown, go and grab yourself a toque. It's warm, it's comfy, it's cozy. We got cold weather coming next week, and keep yourself comfortable after you sign the petition, after you do all those sort of things. We want everyone to have a great weekend, but the only way we can have a great weekend is if we all sign the petition to call Her Honor, Lieutenant Governor Lacanny, to reserve royal assent. We'll see you next time.
The following message has been authorized by Alberta Accountability Alliance. abpolyca@gmail.com.